When you are arrested for a DUI in California, two separate legal processes start at the same time. One is your criminal case in court. The other is an administrative action by the DMV to suspend your driver's license. The DMV case runs completely on its own track, independent of whatever happens in court. You can lose your license at the DMV even if your criminal case is later resolved in your favor. After a DUI arrest, the arresting officer typically takes your physical license and hands you a pink temporary license. Printed on that form is a critical deadline. You have 10 calendar days from the date of arrest to contact the DMV and request a hearing. If you miss that window, your license suspension goes into effect automatically without any hearing at all. Requesting the hearing also keeps your temporary license valid while the process plays out. A DMV administrative per se hearing, sometimes called an IPS hearing, is narrower than a criminal trial. The hearing officer is only looking at 3 specific questions. First, did the officer have lawful cause to stop or contact you? Second, was there a lawful arrest? Third, was your blood alcohol level at or above 0.08%, or did you refuse a chemical test? The officer is not deciding guilt or innocence. They are only deciding those 3 factual issues. The DMV builds its case mostly from the DS-367, which is the sworn statement the arresting officer fills out at the scene. That document covers the stop, the field sobriety tests, and the chemical test results. As the person requesting the hearing, you have the right to see all of that evidence in advance, to subpoena the arresting officer to testify, and to cross-examine witnesses. You can also present your own evidence, including an independent blood test if you obtained one. These procedural rights matter because errors in the paperwork, or in how the chemical test was conducted, can be raised as challenges. If the hearing officer rules against you, the length of suspension depends on your history and the circumstances. A first offense with a completed chemical test typically results in a 4-month suspension. A first offense refusal to take the chemical test carries a 1-year suspension. Prior offenses within 10 years make those periods significantly longer. A restricted license that allows driving to work or an ignition interlock device may be available depending on your situation, so the full picture depends on your specific record. Preparation starts with that 10-day call to the DMV. Request the hearing, ask for the evidence package, and review every page of the DS-367 and the chemical test records for irregularities. California Title 17 sets out specific rules for how breath and blood tests must be collected, stored, and analyzed. Violations of those rules are a legitimate basis to challenge the result. An attorney who handles DMV hearings regularly knows what to look for in those records and how to present challenges in front of the hearing officer. Results vary from case to case, but doing nothing almost always leads to a suspension. Understanding how this hearing works puts you in a much better position to protect your driving privilege. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.